came out for, again, holding a public hearing. So I just want to publicly thank you for your continued leadership. As someone who is a past president of the NAACP, I know that there's still so many disparities within our criminal justice system, and oftentimes, you know, African Americans are on the wrong end of it. And I think that you know, former President Kennedy said it best: let us not seek the Republican answer or the Democratic answer, but the right answer. Let us not seek to fix the blame for the past. Let us accept our own responsibility for the future. And I think it's incumbent upon us to find solutions so that we don't keep having, you know, Sandra Bland's all across the state of Texas. So I just wanted to publicly thank you and commend you for holding this hearing to hold people accountable. And I just wanted to say thank you.
Well, you're welcome. And also, I would like to set the record straight on the Sandra Bland Act. It was not a mental health bill. It was a criminal justice reform bill that included elements of mental health. I read all the time that it was a mental health bill. It was, but it was mental health in terms of how law enforcement and jailers interact with individuals in their jails. It was a criminal justice reform bill because we passed something called de-escalation policing. And every peace officer in Texas has to be trained in de-escalation policing, which helps to create an atmosphere of doing what peace officers need, which is to have a the actual person they stop or whatever else actually be in compliance in a different way than what we see as command and control policing, which is used to actually have the same thing happen. The most important part is that the person that the peace officer is dealing with is responding to the commands of the peace officer. And you can do it in different ways. There is no other state in America where every peace officer has to be trained in de-escalation policing. And I'm not talking about the mental health kind. These are scenarios, and it's a big deal. When I talk to people around the country, they say, how did you do that? We can't even get it done in our own police force. How did you do that? The other piece is that the data that is being used now is the data that was part of the Sandra Bland Act that gives us a clear depiction of what is actually happening out there on our roads, in our cities, counties, and our state highways, or else we wouldn't know. And it's presented in such a way that we know it's evidence-based, and that's extremely important. The other piece, two pieces I think are important, are the fact that in the bill, and it was in some other bills, and it's a good deal, we have where a person can file a compliment or a criticism or of the peace officer, actually rate that police officer. Before, you had to go actually into the police department to file a compliment or complaint. Now you don't have to. You can do it by email. You can do it written on the back of a ticket. You can do it in any way that actually shows that how you felt about what's going on. Most people, after whatever occurred, they would just go home. Mad, but go home. And of course, they're not going to take that extra step to go to wherever it is in whatever town or whatever city to make a complaint. The last part is, I think, really important because of some cases that are going on right now, particularly one in Baytown. You know, I passed a law that said all peace officers would be trained in at least 16 hours of crisis intervention training, which is de-escalation training for people with mental illness. And in the Sandra Bland Act, we increased that to 40 hours, which is the standard. So we have different things in the bill, but for some reason, when, and this is probably just most importantly for anyone here, people keep writing that it was a mental health bill. Yes, it was, in some senses, but mental health related to the criminal justice system, and some rural things that we need to do. But most importantly, it took us steps forward in criminal justice reform. And so because I can't have a press conference on that, I wanted to make sure that anyone writing about this or watching it, instead of making a comment about the bill and you haven't read it, would you read it so that you understand what actually passed? I also want to thank, because I didn't get a chance to do it then, thank the governor and the lieutenant governor for leaving, for allowing, because if they didn't want it, it wouldn't be there, allowing the criminal justice reform pieces of that bill to go into effect. So that's what I wanted to open with. And I also want to make sure that recognize Miss Geneva, who goes by that lovingly by her friends and family, but she is Sandra Bland's mother. Her name is Geneva Reid-Veal, and she's joined us today to hear about this and as an obviously more than interested party, but she won't be testifying, but she is here because she's interested in, of course, what transpired with her daughter. There's nothing I can do in law to ever make her feel that justice would ever be done. There's just no way. Because when you lose a child, that feeling of loss is never going to go away, and no matter what we do, there's nothing that is going to say that we've addressed the reason why she lost her daughter. So with that, we're going to start the hearing. And yes, sir. Yes, Representative Biederman.
I just want to confirm some of the things that you said. I was on the committee last year, or last session, and you're right. When we talked about this bill, it was about the criminal justice side of the bill and the de-escalation and how to treat people and things like that, training. It really wasn't about mental health for the most part, even though that's part of it. So I just wanted to confirm that. I was on the committee, and it was an important bill. I learned a lot. It wasn't something I dealt with a lot in my district, but I'm just grateful for it, and I learned a lot, and I just wanted to confirm that, yes, that's what our deliberations were on the committee.
Thank you, Representative Biederman. We did, I don't know how many hearings, 5 to 7 hearings on the Sandra Bland Act during the interim. Between 2015 and 2017, coming into the session, we wrote a bill that, you know, quite frankly, if there's some metal that's valuable on another world, it was that standard of criminal justice reform bill. I never thought that we would pass everything that was in the bill, but anybody in any state can pull up House Bill 2702, and they know what the highest standard is of criminal justice reform that could ever be passed in any state or this nation to deal with the situations we're dealing with. And I think that's very important. I wanted it on the computer, because nothing gets on the computer unless it's in the filed bill. So with that, we'll get started. The chair calls Stephen M. McCraw, Director of the Texas Department of Public Safety, and Philip Atkins, General Counsel for the Texas Department of Public Safety. And please state your name and who you represent for the record. And thank you for being here this morning. You went through, you know, Mr. McCraw, you went through a lot with us in those interim hearings, and I appreciate everything that you've done and the department has done to get us to a place where we are. And I know it was a little rough in the beginning, but it turned out you have been a very good partner in making these changes and being a stand-in for, quite frankly, for every police department in the state. So thank you very much for doing that.
And thank you, Mr. Chairman. Stephen McCraw, Director of Texas Department of Public Safety. First, I want to echo some of the comments made by some of the members here. I want to thank you. This was clearly criminal justice reform. And we recognize that at the time, and we are a better profession, we're a better department today because of it. We're more transparent, and we certainly have better training, and I think all law enforcement agencies benefit from it. So it's not surprising, because I think the Texas legislature has always been on the front end of taking care of business, that this was passed, and thankfully it's in place. I would like to begin by thanking you again, Mr. Chairman, for giving us the opportunity.
And I don't know if you did, but please state your name and who you
Yeah,
represent.
it is, sir. Steve McCraw, yeah,
Right.
sir,
Just wanna
Director of
make
Texas
sure.
Department of Public Safety, yes, sir. Thank you again for giving us the opportunity to refute, okay, this gross misinformation that was reported to the public regarding the discovery process, both civil and criminal. You know, clearly, we've got an obligation to fully comply with those rules, those laws, those guidelines, and the department takes that very seriously. And this investigation into the tragic death of Sandra Bland, you know, all things, we promised you one thing, promised you a thorough and meticulous investigation by the Texas Rangers, and we provided that. And on top of that, you know, we also provided promised you that not only that there'd be no stone goes uncovered, but that we fully comply with all the particular requirements in that regard. I would like to, with your permission, Mr. Chairman, to have our general counsel quickly review the facts that refute the misinformation that's out there. And understandably, I would be upset in your position, and every member should be upset if, in fact, the Department of the Attorney General engage in that type of act. It is unacceptable. And if you don't mind.
No, I think that's very appropriate, and then I will have some questions, because there's some conflicting information in the reports that I've read.
Yes, sir.
That, you know, quite frankly, if they're true, then there's some discrepancy there that we need to clear up.
Yes, sir. Go.
Thank you, Mr. Chairman. I'm Philip Atkins, General Counsel of the Department of Public Safety. Thank you for your leadership in this area, and thank you for the opportunity to clarify the public record. The Department of Public Safety has not illegally withheld evidence from Sandra Bland's family or her legal team. The video that she recorded during the traffic stop on July 10, 2015, was provided to counsel for Ms. Bland's family by attorneys representing Waller County. This occurred on October 30th, 2015. The certified mail correspondence documenting delivery has been maintained in the litigation files of the Office of the Attorney General. We will provide that correspondence for the committee. When you look at that.
Were they allowed to keep it?
Were they allowed to keep it?
Keep the information?
There was a protective order that was entered in the civil litigation.
So they weren't allowed to present that to anybody other than themselves?
During the course of the civil litigation.
Yes, during the course of the civil litigation.
They could not.
But your claim was that because there was an immunity to the department or to the state from having that information released to the public, it could never be used in all of the cases publicly, right? You've said that. Y'all have said that. The AG has said that.
No, that's not the case, Chairman.
Why are they saying it?
The OAG made objections appropriately, I think, at that stage of the litigation. The civil suit was brought 22 days after the event.
I understand, but if somebody has information and it can actually be used, or the public could actually know, you can't have it both ways. It either prejudices the criminal case or accents the discussion that's happening in the criminal case, or it's used in the civil case. So the reason nobody knows about this, quite frankly, is because that information was not allowed to be released. And you all didn't release it, did you? Did you release the video?
Yes, we have
To
released
whom?
the video
No, to
to
whom?
KXAN TV
Okay, but
on
that's
September
not, did you release
5th,
it to the
2017.
public? Did you release it to the public?
Sir, we released it to a television station.
Did you send it to
So
me?
yes, we released it to the public.
Did you send it to me?
No, sir, I believe we released the Ranger report to you that contains
Yes.
a detailed description of
But did you
the
release
video.
it to me? Do you know that the disc you sent me, you just data dumped everything in the disc? with no way to find things in the disk?
I
It was-
believe we sent you a 94-page
I'm telling you what you
Texas
sent me,
Ranger report.
because I tried to go into the disk you sent me, and we couldn't make heads or tails out of it.
I wish you had brought that to my attention, and I would have assisted in that regard.
Well, but do you think that's an appropriate way to give information to a member of the legislature?
Absolutely.
You do? You mean actually giving a disk where you can make no heads or tails of it? You
we've-
think that's the appropriate way?
No,
to
I
do
mean,
it?
you should always make heads or tails, and we should
Well,
make
I'ma
that.
tell
But,
you, that's
Chairman,
why
I do
I'm-
want to say one thing, though, Mr. Chairman. You know, we released the video, the dash cam, early and often because we felt it was important from a transparency standpoint. I know that in criminal
why we have
investigations.
dash cams.
That's right. We wanted to get it out there.
Thanks to Royce
the
West,
public.
by the way.
Amen. And we wanted to get it out there because, you know, we understand, you know, our complicity in that, and we get it out to the public. The only reason any information wasn't provided out earlier while we're conducting the criminal investigation, because that's what we're doing, conducting a criminal investigation against Trooper Brian Encino. We did not want to compromise it in any way.
Because you know in the Sandra Bland Act, you wouldn't be able to conduct a criminal investigation of your own officer, that we have outside people that come in.
Yes, sir. We invited the FBI, as you recall, and also the Civil Rights Department, Department of Justice Civil Rights Division. They looked at the video. They chose not to work it as a civil rights case, but instead to monitor our investigation, which they did. They also provided us assistance in terms of Sandra Bland's iPhone, in terms of accessing it and retrieving that video, and they provided that information back to us.
So you could have sent me the Ranger report, and still you didn't send me the video, because seeing the video really makes one think differently about what actually occurred. Because we had one point of view, and that point of view was from a dash cam. We didn't have body cams at that time. And it shows a very different scenario. And as we talked earlier, that's the reason that Trooper Encino was indicted for perjury. Well, we didn't know the reason why, because we hadn't seen that point of view. I hadn't, till just recently, seen that point of view of the circumstance. So we went through all these hearings here for all those months. And, you know, you can say whatever you want to say about what you gave me and what you didn't give me in this committee, but the reality is it effective in terms of what you're able to see? Because I can see things that other people can't see, and I'm just surprised that I never was shown this video, because you can show me things. I can't show it to other people, but you can show me things that other people can't see, and I have to keep it confidential.
And we presented the report of investigation
I'm not
as
talking about the report.
what you requested.
I'm talking about the video. You mean you can't give
There-
me things that I don't request?
We can give you, we can't know what it is that you want to look at.
Well,
If the-
you know,
all
come
of the
on.
evidence that's.
Sir, we had all these hearings. You knew what I wanted to look at. If you say that, then that just doesn't fit the circumstance.
The
Because
Ranger.
that means what I'd have to do is have a hearing on everything and go through 50 questions with you, which is what I'm trying not to do.
The investigation included jail surveillance video footage. The investigation included a lot of evidence. The investigation was meticulous, thorough, and professional.
I didn't say it wasn't. I
And-
didn't say it wasn't.
and
What
to-
I said was, you didn't present those things. It was only that I would have to ask for it. And that's one of the main reasons I'm having a hearing today, because if I haven't asked for something, I'm gonna ask right now. Give me everything that you have related to the Sandra Bland case, and in a documented and cited form, and bring it to me.
Yes, sir.
Everything.
Fourth thing we have for you and members
No,
of
no, wait,
the
I
committee,
want-
we have the Texas Ranger report that's
You
really.
keep going back to the Texas Ranger
Well, no,
report.
because
I'm
it does
not
exactly
asking you
what you
about it.
asked him, Mr. Chairman. It meticulously identifies all the evidence and describes all the evidence in the investigation from day one to the conclusion
So
of the
regardless
investigation.
of what it describes,
Yes.
obviously, you didn't give me the film, so I'm asking for everything that you have regarding the Sandra Bland case. If it's video, I want the video. If it's audio, I want the audio. If it's any depositions that you did with anyone that was involved in this, I want everything.
You'll have everything.
Thank you. So please continue. Did you have a
Mr.
question?
Chairman, yes, I did. I just wanted to follow up on a couple of your questions. What was the chain of custody? I hear the chairman kind of asking for this and that, but I want to know this.
The chain of custody regarding the,
Evidence,
That-
all the evidence.
Again, it's set forth in this report. We'll provide it to you, ma'am,
Okay,
if you
so
don't mind.
you've got-
It sets it in detail. In fact, it describes each piece of evidence.
as far as the cell phone video goes, it was gathered at the time of the arrest by the Texas Rangers. A search warrant was secured to authorize search of the phone. The phone was downloaded so that the information on the phone could be reviewed. That process took till September 17th, 2015. The incident happened July 13th, 2015.
So a follow-up question. When you sent me that disc with all of that stuff all jumbled up on it, was the video in that disc? Do you know if the video was in that disc?
Well, the most
No,
recent.
I'm asking you a question, a direct question, sir.
The video would not have been in the PDF of the Ranger report.
No, it
And
was
that's
more than
what-
the Ranger report that you sent me. It was a bunch of data all jumbled up. Was the video in that disc?
I don't know that it was.
Okay,
I
so-
don't know that it was, but I know that the Ranger.
But what no, you keep going back to the Ranger report. I'm asking you, did you send the video to me in the things that we asked for in a way that it could be identified as the video? Because you all clearly told me there were some things I could share and some things I couldn't share. I'm asking you a direct question, because I can't figure out what's in that disc. And it's not just the Ranger report.
I mean,
So I'm asking a direct question,
Mr.
and I
Chairman,
want a
if-
yes or no answer. Was the video in that disk of information you sent to me?
I don't know that it wasn't. I'd like to review the disc that we've received and make sure that
Do
it
you
was.
think that's an appropriate way to give information to a legislator or to anyone else when you just data dump onto a disk? It was just a data dump. I mean, just stuff.
Well,
One of the things we provided was a paper hard copy of the Ranger report.
I'm not asking about the Ranger report, sir. I'm asking a specific question. In that messy data dump disk, was the video sent to me in that disk? And this was done under a Freedom of Information request.
well,
Was-
I wished I would have known, frankly, that you
No,
you
you
viewed it
should
as a.
know. Your people
Hey,
sent
well,
it.
that was a data dump that you had some problems in terms of
Well,
reviewing
you
it.
should have
but,
known. You sent it.
Yeah.
We never had any word from you that
You didn't
that
have to
you
have
had
word from me.
any
Is this-
problem
Is this how
accessing the
you
data.
normally give things to people, sir?
Absolutely. I believe we responded
You
to your
normally just
request
dump
in an
data?
appropriate way.
You
I don't
normally
believe we
just-
dumped data.
Sir, you did. I can give you the
Hey,
disc.
well, we'll go ahead and, if you say we did, we'll just say
You
we did.
did. Why
Okay,
would I sit
that's
up here
fine.
and
All right.
lie?
All right, Mr. Chairman, let's assume that we did, right?
Right.
For purposes, right? We'll move,
You did.
okay. Well, we did.
So I'm asking a
Right.
question because your lawyer's here. Was that information in that disc? I'm not asking you about the Ranger report.
We'll go back and review what we provided you, and so we can answer it correctly.
Because we couldn't make heads or tails out of it. And if that's how you're treating these press people out here, I feel sorry for them.
Yeah.
Mr. Chairman,
Yes, sir.
can I ask a couple questions?
Yeah, because I do want him to get finished, but this is the piece that, if anybody wonders why I am skeptical about some things, it's because that's what was done to me as a legislator.
Yeah, and I wished I'd have known,
Well, you
You
should have
felt that
known,
way.
all these people
Yeah.
work for you.
yeah. Well, I wish I'd have known, but, that said,
Counsel, you stated earlier that there was a protective order issued. Which judge issued that protective order?
There was a protective order issued by Judge David Hittner in the federal civil litigation.
You said you were able to retrieve the video from Ms. Bland's phone through your own investigative measures, and then you retrieved the video and you stored that, correct?
yeah, we actually used the FBI's computerized
The
response.
Regional Computer Forensic Laboratory.
Okay. Whatever happened to the phone itself?
The phone has been released to Ms. Bland's mother.
When?
When? Yeah, thank you.
September.
I believe in June or July of 2017.
So after we left session and did the bill.
I think that's the case,
Was-
yes. It was, the active phase of the criminal case ended on June 28th, 2017. That's when the indictment against
Do
Trooper
you
Insignia
agree-
was released.
Excuse me for interrupting. Do you agree that, based on the evidence in the video, that perjury was the highest charge that could have been brought against Trooper Insignia?
I really can't
I don't know, y'all were the ones
speculate on
doing-
the
You did the
prosecutorial
investigation.
decision.
You keep telling me about the investigation you did. I'm asking a direct question. You don't have to speculate. You're a lawyer.
So what's your question?
My question is, in the criminal case, whether or not that was the highest indictment or the most stringent indictment that could have been brought against Officer Encina based on that evidence, and with the special prosecutor settled that case in such a way based on that evidence, because we didn't know, I didn't know, and I didn't know, I hadn't seen the video, and it just tells such a different story. It definitely shows perjury.
And the Rangers conducted the investigation as an oppression investigation. And of course, as you know, we refer our investigation to the district attorney, and they make the call on those lines. One of the advantages of bringing the FBI and the Civil Rights Division of the Department of Justice early on is that, of course, you can mirror, and there's concurrent jurisdiction, and they can also file charges federally on a civil rights or color law investigation.
So, as the legislature, we have the same authority in subpoena power in anything as the DA.
Yes, sir.
So, you knew we were doing hearings, you knew we were doing an act. I'm trying to figure out, did I have to subpoena the information in order to understand what was going on?
I wouldn't think so.
Absolutely not.
Yeah, but did you volunteer it to me?
Presented pursuant to
No,
your
did you
legislative
bring it
request.
to me?
We did not present all of the evidence that was collected
So
in
would you
the
think that this committee would have
investigation.
been interested in that? I mean, we
Well, I can
had,
assure you, if we had it back at that point in time, we'd have provided it to you before the
had
committee, because frankly, I mean, we put it on our YouTube as well, because that, only
When?
after
I
we.
keep going back to the question that he's
Only
asking.
only after we can do it legally.
After we did the bill,
Yeah.
after we had all the hearings,
Yeah.
after everything that occurred, you put it on YouTube.
No, we haven't.
It was put on YouTube on July 21st, 2015, 7 days after the event.
The actual video
No,
that Ms. Bland.
The dash cam video.
Sir, but see, again, we all know the dash cam video was on, we had that. I'm talking about the information we didn't have.
Yeah, the only time that information didn't have or was protected and wasn't released.
Why was it
while
protected?
when the criminal investigation was ongoing.
Why is it we're protected?
Because the criminal investigation was ongoing.
So
To
what
the
makes
public,
that-
to the
what
public.
makes that-
You would still have a right to see it.
Yeah, but why didn't you give it to me? You knew we wanted everything.
Yeah, as soon as we had it in, September is when it was done?
The video was collected in September. The Ranger report wasn't completed
They're talking
for
about the
some
Ranger
time.
report.
Evidence was collected over many months. It was a long-term criminal investigation.
Yeah, but I've been here 27 years, sir. I'm a long-term member.
I have a follow-up
Hey,
question.
Ms.
Speaker Moody has a question, and we'll go back.
Thank you,
to
Mr. Chairman.
Cole,
I-
and I'm gonna
Appreciate it.
leave it to the lawyers now.
So, I think you've touched on a very important point here about public information and when that's available to the public and when it can be protected or not. Now, there are exceptions that agencies can raise, right? There's an ongoing criminal investigation. The agency can say, we're not going to release this information currently because there's a current ongoing criminal investigation, right?
Yes, sir.
And if they raise that, that's an absolute bar. And the public policy behind that is, we want the investigation to not be, essentially impacted by other forces. We want to be able to kind of marshal that through the process and get to a conclusion, wherever that may be, right?
Absolutely, especially in this case. I mean, or any case, but this case was very important and we didn't do anything that could undermine the prosecution.
And so releasing the dash cam footage early, you actually didn't raise the exception. You put that out because some agencies will do this depending on the case. As a matter of public policy, better not to utilize the exception. They go, let's just release this at public, right?
Exactly, yeah.
Okay, so
What-
that was a
after-
choice that was made by the agency back then.
Yes, sir, after we got the permission of the district attorney and the family.
Okay. There is another exception that we have there that says if no conviction or deferred adjudication is had on a case, so if there's no conclusion, right, that ends in a conviction or deferred adjudication, that material can also be withheld under the Public Information Act. That's the back end. And the public policy reason is, well, if no one was convicted or nothing really happened, you don't want to sully the good name of someone by releasing all the information. You're aware of that exception too.
Yes, sir.
So was Trooper Encina ever convicted of anything?
He was not.
So actually, under the current law, I want people to understand this, under the current law today, because no conviction was had, that video, under the law as it stands, could have been secreted forever.
We could have, within our discretion, exercised that
Do
exception.
you think that's
We chose
the-
not
do you-
to.
And I appreciate that, and there's a question about when it's released, I appreciate that, but do you think it's good public policy that in this case, had your agency not made that determination, that information would have never been available to the public?
I don't think that's good public policy, no.
I appreciate your opinion, and I hope that we change it this session.
Mr. Chairman?
Thank you. And we'll go back to Representative Cole and then back to Representative Dominguez. It's really good to have people on this panel who were prosecutors. So I think that's important, and Representative Dominguez was a prosecutor. Representative Cole.
No, I wasn't a
I
prosecutor.
know, but you went to law school.
I did.
But I watched Law and Order.
It's the Public Information Act that covers this has several exceptions. And I'm assuming that, I think you just said that the DA made that determination. Is that correct?
The decision to post the video early in the case was made in concurrence with the district attorney. We wouldn't have posted that if the prosecutor disagreed with that decision.
Talking about the dash cam.
The dash
Let's
cam
be super
video.
clear what
Yeah.
we're talking about.
Yes, sir.
Well, I'm trying to figure out if the dash cam is the same as her phone. Because I know that the phone was exempt. And the question is, why?
The phone contains a 39-second clip that she was able to take during the traffic encounter. The audio is identical to what is shown on the dash cam. It shows a different perspective than what's on the dash cam. It shows her perspective of Trooper Encina.
Okay, I don't want to, get too far down the phone while everybody else is on the dash cam. I just wanted to point out
Now, the
that-
dash cam, let me just be very clear. The dash cam was released. We all saw it. We all know what it was. That has nothing to do with why we're here today.
I understand. I
I'm
just
just
wanted.
saying it to them because they're just trying to confuse the issue.
Okay, I just wanted to make sure that your point was made clear and that when we talk about the Public Information Act and exceptions that were used to not release information, that also includes the phone. And that was all I wanted to do, Chairman.
No, you're doing well. The question is, I've been here a long time, and agencies will tell me, they don't wait for me to ask. They'll say, these are things that you might want to see. You cannot release them to the public because that means they want to be seen as fully cooperating with the legislature. And so when someone tells me I didn't ask for it, that becomes the type of thing that really makes me angry. Because if that's how we have to do everything, I'll just do an open records request a day. Because that's what it makes members do. And because we know there's information we can't release, then why hold it back from me? So that's been part of my question, and You keep answering it with the Ranger report, and that's the
Well,
reason.
the only reason the Ranger report was mentioned because it was described in the Ranger report. So if you've received
But
it,
it's not the video.
no, it describes the video in
It's
detail.
not the video, because the video shows something
Yes, sir.
very enlightening based on the actions of the trooper. Because watching that video, which you cannot see on the dash cam video, is when he changes his point of view, and says, "I will light you up." When all she had in her hand was a cell phone, filming him. So would you light people up for filming him? So
Not at all.
that's the reason why I'm concerned about this, because it really does show a totally different circumstance, totally different than the dash cam. Representative Dominguez.
I'm trying to get some clarity on the timeline of events. So we know that Ms. Bland dies on or about July 13, 2015. She'd made her video a couple of days before. There's no doubt that that video belongs to her, correct? Legally.
That's right.
At what point does her heirs or her estate receive the phone? I think you had said June of 2017?
And I'm not
More or
sure
less.
of that month, but it was released after the active phase of the criminal investigation, after the charges were dropped.
So a little bit
against-
less than 2 years.
I think that that's correct.
And a 2-year-long investigation where all the evidence was before the district attorney's office took that long to process?
That's right.
Okay, and not to cast blame on anybody, I'm just trying to get the timeline here. When that phone was returned to her estate, was the video still on that phone?
That's my understanding.
It was not scrubbed, it wasn't erased?
No, the evidence was handled in such a way that it was not corrupted.
At any time, did the estate's attorneys make a request for discovery of either your offices or the district attorney's office
In the,
in the civil case?
yes, there were discovery requests in the civil case.
And you said at some point, the district judge there issued a protective order on this specific video, correct?
No, sir. The protective order was issued regarding all of the evidence in the case, since it was an ongoing criminal investigation.
Did that district judge in camera or in other fashion get a list of what that evidence was that was going to be held back until the criminal case was done, thoroughly investigated?
The judge reviewed the Ranger report in camera before making a decision.
Did that judge know that this cell phone video existed?
If he read the Ranger report, he would have
Sir, just answer the question.
seen.
And if you don't know right now, that's fine. You can follow up with me.
Oh, sure.
To your knowledge, do you know if that judge knew that this video existed?
I was not present for the in-camera inspection, but I know that the report says that Ranger Ellison examined the data extracted from Ms. Bland's iPhone, Exhibit 11.3, and found Bland was able to activate the video recording function of her phone during the traffic stop with Trooper Insignia. The video recording depicted Trooper Insignia reaching into the car and then removed his taser from his holster while he ordered Bland out of the vehicle. The recording lasted approximately 39 seconds.
So
So
are
he
you-
had that information.
So they had the written summary of what the video demonstrated, but possibly not the video itself.
I think that's correct. I would think that he didn't have the video at that time.
So, no disrespect to your line of questioning.
sir.
But the video, anybody in this room that has seen this video, that description of the video is not what you see on her video. That's not what you see.
I think it's an accurate description of the video.
You do?
Absolutely.
You do?
Yes, sir.
An accurate description of the video that he said, "I'm gonna light you up with a taser," when all she had in her hand was a cell phone? You think that's an accurate description of that when she made no threatening motions, no anything?
Well, the "I'll light you up" was posted in the original video. That
Yes,
was
but
always
I'm talking about
apparent.
the point of view of her cell phone, sir, not the dash cam video. It is totally different.
Yes, sir.
point of
Yes, sir. They're different perspectives.
So in the perspective of the description in your Ranger report, since you read it just to us, that description is far in a way different than what you see in the video from her cell Did somebody do something with this, where's Brandon? Okay. Far different from the description you just read.
I disagree with you. I think it's a
You can
fair
disagree all day
and
long,
accurate
'cause I don't have
description
lying-
of the video.
I don't have lying eyes, sir. I'm just telling you, I've looked into this more than anyone, and I was surprised, quite frankly, because you even said he committed perjury. So what did you base the perjury commitment? What did you base it on? That video?
That was a prosecutorial
I'm
decision.
understand, but everybody's told me that, so I'm trying to understand, sir. It doesn't compute.
I
You may
believe,
disagree with me, but it doesn't compute.
I believe the perjury charge was based upon his statements that he was in fear for his safety.
Yes, and the video shows that he wasn't, doesn't it?
I think
The video shows.
all of the evidence.
Video shows that he wasn't, doesn't it?
Shows that he wasn't in fear for
of
his
Why
life.
would he have been?
I can't,
You mean you
I don't see any evidence
You
of
don't
why
have
he would have
eyes?
been.
Anybody that's looked at this, it's very clear that he not only didn't look in fear of his life, but the point of view clearly shows that he did commit perjury in terms of how he described the circumstance. You wouldn't be able to tell that from the dash cam video, but you can tell that from the cell phone video, sir.
Well, I think you can tell it from the dash cam as well.
It
There's
doesn't matter.
There's no question, Mr. Chairman, there's no question that he he was not in fear of his life, okay? We know that. The
Why can't you
investigation
just answer
concluded
the
that.
question?
It
Why do
concluded
you-
that. And
Why
then-
do you say that you can't make that determination?
Well, I can, I'll make a
You
determination.
can,
I
thank
would have fired him for that, okay? And well, in fact, I did
And
fire
we
him.
did.
Last time I checked, I did fire him for
Yeah,
it.
you did fire him.
Yeah.
Later.
Yeah.
Yeah, which I appreciate. I wish he had been prosecuted for more than just perjury, quite frankly, after seeing that video. Representative Dominguez.
If I can just follow up, and this really goes to the heart of information that we release to the public. And I understand that at times of stress, incidents like this happen and draws a lot of attention, not just local, but national, sometimes international attention. And we are looking to law enforcement, and we want to be reflexively defensive of them because they do put their lives out on the line for us to keep us safe. There's no doubt about that. That's not what my line of questioning is about. My line of questioning is about there's an inherent contract that we have with law enforcement, that we will at all times believe that what they do is in the public good and never in the public harm. And we hope that all our officers are fully trained, which is why we have the new legislation that we do. So my question to you is, when the decision was made to release just a dash cam video, the decision makers, did they take into account the cell phone video as well, one? And two, did they decide, if they had the cell phone video too, that the cell phone video was perhaps a little bit more inflammatory about the conduct of the police officer? And if that's the case, can you explain that to
Well,
us?
at
I was involved in the investigation, involved in that point to make the decision to release the video. At that time, we didn't have the clip, the 39-second clip. It went through, first of all, we had to get the password. We had to go through a process in terms to get by the password, which involved a contract with a private company to be able to get that. Then, after we got the search warrant, then it went back to the FBI laboratory before we finally got the evidence. So at the time the decision was made, in terms of release the video, we didn't have the video clip. Now, we knew of it simply because we heard it being said on the video, in the dash cam video. The trooper mentions that, or you hear that, with the phone. So we knew there was something there, which is one of the reasons why we had the search warrant, wouldn't be able to get in and take a look at it.
So after you received the cell phone video then, why not just come clean with the public and say,
It's not even a matter of clean. I couldn't agree more. There's nothing there that we wouldn't share, and we did with certainly the civil attorneys had it and the defense attorney had it.
I think a lot of what happened was for those number of days after her death, we're trying to figure out what happened that day that made this officer do what he did to bring her into custody. And I think if we had seen that video, the public might have a different perspective on things and possibly in a more positive light. So going forward, what do you expect your public policy to be when something like this is available?
We've done it, and we'll continue to do it. Transparency works for us. In fact, I mentioned the chairman earlier, we talked about video cameras. It would have been important, and what we have right today is every trooper has a video camera, a body camera, so you get two different perspectives in that regard. HD quality has made an improvement, so on sound and also on the video itself. It's very important to get that perspective, and quite frankly, you know, it's not about just, it's holding ourselves accountable, but it's also how, you know, in many situations, that video has put troopers that were accused of things that were absolutely false and malicious, has proven that the facts of it that has been disputed immediately. So there's value in that, and there's value to provide that video and get it out as soon as possible.
Thank you. I appreciate your kind of testimony.
We're going to go to representative theory, but I would, do you think that the actions of rogue peace officers, the very, very small percent of those in terms of deaths or other things that have happened to people that they've stopped, that wasn't the impetus for for body cams?
Absolutely. I think that it gives, one thing for sure, it
So-
reassures the public that you know, whenever a police officer interacts with it, that you've got a record of it and it's recorded in that regard. And but it works both ways. It also
Right.
ensures that if there's allegations that are false, that will clear the officer.
So this was, in a sense, Sandra Bland had her own body cam,
Yes, sir. And
but it wasn't treated
And you know
that.
what? You know what? Citizens are entitled to record
exactly
police
right.
officers. They have every right to do that.
But would that have occurred? Would that be that wasn't people's opinion, obviously, in 2015. The people's opinion about recording came after the fact that those videos were showing something different than the narrative, which brought forth video cams. So, you know, we just need to get the history right on this, that was not something that people wanted. It was something that people then had to do.
I mean, entitled to do, and police officers don't have a right to interfere with that.
I would agree with that, but I've seen enough videos when the people who aren't following those rules have said, shut that video off. Hand me that camera. Now, does that go with the spirit that you're saying?
I don't mean, how long we've had our policy?
Well, several years, and that would be a violation of DPS
Yeah, but
policy.
several years means what? After Sandra Bland?
Yes, sir. I think
Okay, so-
probably after 2015, after
Well,
Sandra Bland.
so there we go. I don't think I have to say anymore that that's what the impetus for your policy was, not anything other than that, because of the change in social media and video and people being able to see things they weren't able to see before. And so you didn't go out and say, oh, we're going to do a policy before that. And maybe if you had had that policy, we'd be talking about a different thing right now, right? So Representative Theory has a question.
Thank you, Mr. Chairman and members of the committee. Excuse me, I appreciate the privilege of being able to sit on the dais with you all here, and it's an honor to serve on this committee last session. Mr. Atkins, I'm going to ask you some questions, and I think it's really, really important, so I'm going to ask you to be really kind of patient with this, because it really comes down to the crux of truthfulness in my mind about two things. And when I'm done, we're going to have to concede that either one is true and one is going to be true and one is going to be false, I'm pretty sure. I don't think they can both exist. So let me start. On May 7th, your department sent an email to every member of the Texas legislature. And you told us, it says, we want to make sure you have the facts regarding a story that aired on WFAA TV last night. You said the cell phone video at the center of the story, and this is referring to Sandra Bland, is not newly discovered evidence. Now, this came from Kevin Cooper, by the way, your governmental relations chief. You said the cell phone recording is referenced by Ms. Bland in the dash cam video that was posted on the YouTube channel. So you're trying to say, well, it's not new because it was on the YouTube video. You know, it's referenced. But again, as the chairman has been able to articulate, that was not the actual footage that we saw. It was just referenced in the dash cam. So then you went further and you said that it was specifically identified multiple times in this infamous Ranger report. But that means you listed it, correct? You just put it on a piece of paper and said there is a cell phone video, right? Because you can't watch a video inside of a piece of paper. Then you said that report, that Ranger report, was made available to all the litigants during civil litigation. Here's the statement I have a problem with. At all times, the department complied with discovery obligations in the civil litigation. Now, I'm going to go back to something that the attorney has said on public record now in that civil litigation, the attorney that represented Ms. Bland's family. He said, well, let me go back to your video. You made a statement recently that said the premise that the video was not produced as part of the discovery process is wrong, DPS said in a statement. A hard drive containing 820 gigabytes of data compiled by DPS in investigation, including the dash cam videos, which you go further, jail video footage, and data from Sandra Bland's cell phone was part of discovery. Her attorney, Cannon Lambert, has been on the record to say, quote, I've not seen it when shown the video for the first time. This was on May 6th, the day before you sent this letter to every member of the legislature. I'll go back and quote. He says, if they had turned it over, I would have seen it. I've never seen that. Which one is true? Which statement is true? Is that a true statement that he's making?
I take him at his word that he has not seen it.
Okay, so that's a bombshell, because that means if he's the attorney, I'm an attorney, by the way, too. I've done civil litigation for 25 years. The only way I would not see something in a discovery request that I requested is if it wasn't turned over to me.
Or you
So-
didn't look.
Or it was presented in such a way you couldn't figure out what was there or not.
True, but are you then saying that the attorney didn't review the discovery?
I don't know whether he reviewed that or not.
Okay, well,
I
let me-
know that all of the data from the cell phone was delivered to him. I take him at his word that he did not see this video.
Why do you take him at his word that then? if
I
that's
have
the
no
case-
reason to doubt what he is publicly representing, and I can't say whether he saw it or not.
But he should have.
Well, you-
He certainly had it, and he should have seen it.
He's saying he didn't get it.
Well, he got it. He just should have reviewed it, because
He
it
said
certainly was there.
if they had turned it over, if you take him at his word, let's go back to what
No,
his
what
word is.
did-
His word is, sir,
Yeah.
that if you all had turned it over, if we're gonna take him at his word, let's say he's we can't just disparage the man and say he doesn't do his work. You said if they had turned it over, that he would have seen it. So his premise is that you didn't turn it over. So let me go a little further, because when you go back to the email to the legislature, and you really don't say that you turned it over to him. So I want to give you the opportunity to clarify this letter that you sent to the members, because perhaps you're telling us in this email, now that I've read it and reread it, it's pretty clear you're telling us that you actually didn't turn that video over during discovery. What you did is you turned over the dash cam video, and then you turned over the Ranger report during discovery. That's what you've committed to us. So will you go on record today and confirm, and I know you may have just said it, but I'm gonna give you an opportunity to recant that.
The
It
cell
appears in the
phone
letter
video.
you did not turn the cell phone video over during the litigation process.
The cell phone video was turned over by Waller County during the civil litigation. We have correspondence that says, Dear Cannon, enclosed on the thumb drive you provided is
The
the
space
cell
number.
phone download being produced as a supplement to county defendants' initial disclosures. The Waller County obviously were the prosecutors, and I can assume that they had that through that interaction. was a defendant in the civil litigation. The Department of Public Safety was a defendant. Brian Encenia was a defendant, and multiple Waller County employees were
So
defendants
the
in the
question is
case.
when they turned it over.
October 30th,
Okay.
2015.
But the question is, did you turn it over?
It was
We're
turned,
asking you what you did, because we're gonna ask the AG what they did when we get finished. We're not asking you what Waller County did.
no, I don't believe that,
'Cause you've said that you did.
no,
that
I've
the
said that it was
DPS
turned
did.
over in civil
Well-
litigation. We did not turn over the same thumb
So
drive
let-
again that had already
so-
been
so
produced.
Let's differentiate between who did what. Because you keep saying what you did and didn't do, and now you're saying what Waller County did.
No, I've been very careful to
No,
say
you
that it
haven't.
was turned
Well, I have-
over during the civil litigation
Mr.
by a
Atkins-
co-defendant.
Mr.
Yes, ma'am.
Atkins, in the letter to us, the email to the ledge, and you can clarify this for me, you state that the department, this is from you all, DPS department, provided the video to Mr. Collister.
That's correct. On September 5th, 2017, we provided the video to KXAN TV after the active portion of the criminal
It sounds like it's two
investigation.
different things. From what the chairman is asking, it sounds like Waller County turned the video over to the attorney during the civil litigation.
In
And then
2015.
2 years later, you, the department, turned the video over to a reporter.
That's correct. After the active phase of the criminal investigation
Okay.
pursuant to
Well,
a
then can
public
you see
information
how
And,
request.
they would
and Wa-
say
and Waller
that this-
County was co-defendants in this, obviously.
I understand, we're gonna call them next.
Okay.
We're gonna have another hearing. Now I know we have to, but anyway.
Okay, so that was my clarification. So the missing link is, for some reason, if Waller County turned that video over to the attorneys during the civil litigation as part of a request for production, and if they complied with that, we'll just have to find out why the attorney is saying that
Exactly.
he did not see
E-
it and
e-
that
exactly.
that he didn't know of it.
Exactly,
And
and-
he didn't use it in any part of his civil litigation, because from what I've understood, they've said if they had that, the whole course of litigation
Yeah.
would have been different. The claims would have been different. The settlement would have been
And,
different.
and to conclusion, we want to hand out, if we don't mind, we've got copies of this certified mail and also this, that delivered it to that attorney.
Okay, that would be.
We're just presuming that he didn't look at it because we presume that he's innocent.
Can you give me a copy of the thumb drive that you presented and how the information was categorized in that thumb drive? Because if you gave him the information the way you gave information to me, I tried to look through it, I couldn't look through it. And is that valid discovery? I told you I was gonna ask this question, by the way, and nobody has given me anything, said anything, done anything. And the only reason I'm asking it is because of the way you all responded to me.
What's the question?
I don't have to ask a question. I'm saying that you responded to me in a way that I couldn't make heads or tails of the information. Does that mean you would have responded to somebody else in the same way? So tell me, is that your policy in an open records request or any request just to do a dump of information with no way of figuring out what's what, by what date, or by anything? Is that what you do?
Absolutely not. We
Well, that's what
respond
you did with me, so
appropriately to
Is
public
there something
information
different
requests.
about me than somebody else?
It was my intention to provide you with,
Yeah, but you knew what you provided me.
yes, sir.
So you knew it was done in a way that wasn't responsive.
I didn't, if I had known that,
How would
it
you
would have been
not know that?
corrected.
You're the attorney.
Hey, Mr. Chairman, when we provide this, I think we provide this letter afterwards in this email regarding that, and also the certified date when this was delivered this thumb drive was delivered to Mr. Lambert. I think obviously he had the information, he had the
But
video.
how was it put in the thumb drive?
It was only Sandra Bland's information that was provided on that thumb drive, so he had it.
So I'm trying to
There was
go
no
to the
question that he had
method
it.
of presentation.
It was a thumb drive that contained all the data downloaded from her
Sir, you
phone.
gave me a disc.
From her home, just from her, let's make
From
a
her
big,
phone.
make a big difference.
Contained all the data that I couldn't make heads or tails. You jumbled it up.
No, there's a big difference. See, there's two different thumb drives. This thumb drive contained just Sandra Bland's data. There's two different ones.
The only reason I'm asking is because how you presented the information to the chair of this committee, me, and the request that I made. So should I not be skeptical?
Well, one thing we didn't deliver to you is the thumb drive with all of Sandra Bland's data on it. We didn't do that.
You gave me data that
Yeah.
tried to look through the disk, sir. I've never given it to the press. I guess I could give it to them now so that they can understand
Just
how
a,
you
just a
present
video clip, because I wouldn't recommend, that's personal information that she has on the phone. The only part that's relevant to the case is that 39-second
I'm talking
clip.
about what you gave to me, which gives me an issue with how you present information in any case.
Well,
Because what you gave to me was not responsive.
Well, if we wished you would have known that you weren't satisfied with it,
Well,
because
you
I
should have
guarantee we would
known
have
that
corrected
that
it.
wasn't responsive.
Well,
Don't tell me what I should have known.
Yeah.
You sent the information. Your lawyer had to review it. He's sitting right there.
Yeah.
Absolutely, I did.
So you did. So you thought that was responsive to my request.
Absolutely, I believe we
really
responded
do.
appropriately to you.
You
And if
really
you did
do.
not think so, I would have
So you mean that's
appreciated
how
you letting us know
Goodness gracious!
that
So
you had a question.
that means your standards are really poor, and I would say something else. But we're a family television show.
Yeah.
Because if that's your standard, sir, you all need to look at your standards of response, that you can actually defend that action saying that you thought it was responsive.
Mr. Chairman?
Mr. Huberty, and then,
Colonel, let me try to help you here a little bit. When you provided, and I have not seen the disc, I'm going to take you at your word that you provided the information that you did. When you provided the disc, or whatever you provided the chairman and the attorney and everything else, I think about this as if you're out there providing some sort of roadmap to where the information is at. And what I mean by that, was there an executive summary provided? Was there a table of contents provided? Was there anything that pointed that says, hey,
to
document?
me, there was no
Yeah,
table of
yeah,
contents, just so you
Let
know.
me just finish, Mr. Chairman.
Yes, sir.
So if I'm saying document 1 labeled whatever is this, and you go down, was that provided?
Yes, sir, it was.
It was. So
And-
there
and
was a
it-
table of contents.
Yeah, because we keep talking about this report of investigation. What we didn't do is we didn't file dump on the chairman or anybody else. What we did do is we take a summary of all the evidence and the investigation, and we made sure that certainly that the litigants had it, certainly the defense attorney had it, and the chairman had it as well.
So let me go
I
back.
didn't have the video.
No, you had the list of what Mr. Huberty's talking about.
Yeah, but I'm interrupting because why would I sit up here and lie, sir?
I didn't accuse you of lying,
No,
Mr.
you
Chairman.
are, because I'm telling you what I tried to go through the disc. And you're sitting up saying you didn't data dump, excuse me, Mr. Huberty, you didn't data dump to me, and you did. And any reasonable person would say that's exactly what you did.
Yeah, well, you'd have to read 94 pages and go through it,
Not
because
ta-
it is
I'm
it is
talking about-
meticulous, but at least it's a summary.
No, I'm talking about, you didn't have a table
Well,
of
Mr.
contents.
Chairman,
or anything.
respectfully, I'm responding to Representative Huberty and his question.
I'm the chair of this committee, and I have to recognize him.
Yeah, but it's a different question. It's a different question.
Well, no, because he said even in the
Okay,
disc
all
you
right.
gave to me.
All right, sir.
So it's not a different question.
Okay.
He said he wants to be helpful to you. I'm trying to be helpful to you too, because I'm trying to prevent you from having to recant everything you just said.
You won't, that will never happen, because we've been absolutely transparent through this entire process, and if for
Sir.
some reason you didn't get it, I apologize for that.
Well, you can apologize.
Well,
but-
apologize that you didn't understand it, because you did get it.
What?
Yes, you got it.
What?
We've got this report.
I'm not talking
Yeah,
about the
yeah.
report, sir. You keep going
Yeah.
back to the report.
Yeah, well,
You keep going back to the report, and I'm talking about something different than the report, sir.
well, I can tell you one thing, we fully complied with the civil and criminal procedures relating to discovery, period.
But see, we had to go through this before.
Yeah.
And I didn't want to go through it again, but for you to say what you sent me me was responsive, I just disagree
I
totally.
can't imagine we'd left anything out. In fact, I'm sure we gave, but I will go back and check and
So I'm
review what
gonna
we
send
had.
something to you in ASCII code and see if you can figure it out. Sir?
Thank you, Mr. Chairman. So, Colonel, just want to go back. I just want to be clear. You know, and I don't know what information's been provided in past committees. It's the first time I was on this committee this year. I think where I'm trying to get to, and what I was listening to what Ms. Thury was saying, was that the information provided in such a form or fashion, was there a table of contents with your disk? Was there a disk that showed, you know, was there something that went, because there was, I'm assuming it was not just one file, meaning it wasn't just one document of some sort. Is that accurate? Is there more, there was more than one document that was provided in the disk to not only the attorneys but to the chairman? Is that accurate?
Yes, sir.
Okay. And so whatever that was, whatever those were, was there some sort of table of contents, again, that says, you know, document one or data drive one or whatever it is, references some sort of, it's the dash cam video, or it's the information from Ms. Bland's phone. Was that provided at all, or no? Do you know?
And the only thing we do would go back to the report of investigation, did have a summary of all of that.
Okay.
So you would have to read it, you'd have to read it
Okay,
to
so-
see it. And
okay,
you'd
so
have to go to the
I think
evidence
I got my
section and go
answer.
through it.
I got it. I think I got my answer. So whatever data you provided, it was the report and then all the other stuff that went with it. But
Yes.
there was not really a table of contents for what's in the disk itself. The report was there that went through everything, but there was other subsequent files that were.
Yeah, and I'm going to defer to the general
And I'd
counsel
have
there.
to go back and look at that because we provided information
I
on
think that would be
multiple
I think that would be
occasions.
helpful. I think that would be helpful because whatever you had provided to the chairman and
Sure.
whoever else.
We'll have a record of
I
the
think
cover
that would-
letter and.
That would be
And
helpful.
we want to make sure it's in the right format too, because
Yeah,
it wasn't,
of course.
obviously, if we send it in an ASCII file,
You didn't
that'd be,
send
that'd
it
be,
in
or
that, but it's
something.
equivalent
yeah.
to that.
Well, it would be inappropriate if it's not in a format
But
you
if
couldn't
he
read.
reviewed it, he ought to know, he keeps saying it was
Yeah.
appropriate, and that's the only reason I'm saying that.
Okay.
Thank you, Mr. Chairman.
Mr. Chairman,
Because if you weren't saying that, yes.
if I can just follow up, this actually tailed into what my questions were. It's not unusual in civil litigation for attorneys to provide lots of data and information to opposing counsel. And they'll typically have an index or table of contents describing what they're receiving. Is that what Sandra Bland's estate's counsel received?
With regard to the cell phone video, yes, the cell phone data was produced on its own with a cover letter that says, here's a thumb drive with the cell phone data.
To
So-
your knowledge, the video itself, was it in a format that would have been easily recognizable by her attorney as being a video?
I know that the counsel for the Attorney General's office that represented us was able to quickly find the relevant information on that thumb drive. But
The reason
I
why-
don't know.
I understand. The reason why I'm asking you is, we know different law enforcement agencies use proprietary formats to encode and review video information that might not necessarily be in the same format that we would find on the internet. Do you know if this video was in a proprietary format?
I don't believe it was, but I do know that in civil litigation, if someone sends a thumb drive and then it's not, you can't open it, then the attorneys would talk about that and clarify that
And that's what I'm trying to clarify here, because Representative Theory presented the words of her attorney that I received nothing that I recognize as being a relevant video. I'm not saying he didn't get it. My question is, did he receive it in a format that somebody who's not a video expert would recognize as being a video format? And I'm not saying that was done intentionally. That just may have been done the way the video was retrieved from the phone.
The format was it was an iPhone, so it was all the data on the
So it
iPhone.
would have been a typical
Exactly.
M4V, MP4 format.
Exactly. So, number of different ways they can show it.
Now, and in your testimony is that when her attorney received that information on a drive, he received some kind of index referencing what was on that drive as well, correct?
No, I believe he just received a cover letter that said, enclosed on this thumb drive is the cell phone data, basically. I don't think I'm not saying there was an additional index, that was presented with that.
Any letters that you would have produced to her attorneys or to the court? I believe you referenced the district judge receiving some kind of description of things. All of those documents are saved on your computer somewhere, correct?
They would actually be with the complete file with the Attorney General's office, who represented us in the litigation.
Who's coming up next, and you can ask them.
And it'll be possible to retrieve the originals with their original date and time stamp to show that they were not modified, correct?
I would think that that is the case.
Thank you.
So, since we go in at 10 and we have some other people to testify, I appreciate again you coming, and I know these things are difficult. And, you know, quite frankly, in terms of how you respond, that was a different time. You've even acknowledged that 2015 and 2019 are different times. And so that is our history of going through this information and doing all of these things. Because we actually did the hearings, it made the times different. It made our response as a state to incidents that occur different. The bill made the responsibility of law enforcement different, not because of the majority of people in law enforcement, the super majority, but because of a few bad actors. And I want to make that really clear. And I appreciate how you've educated me over these last almost 4 years. 4 years. And so I know your job is hard. And so I'm not trying to indict you on your job. And you have been very forthcoming. And I appreciate that. Some things, though, you know, quite frankly, we still have some progress to make. With that, I want to
Thank you, Mr. Chair.
Representative Anderson and then Representative Rosenthal, and then we'll have to do another hearing, y'all. But I want to hear from the
Look forward
AG
to it.
today.
Look
Yeah.
forward to it.
Thank you, Mr. Chairman and members. And we sure appreciate you all being here today. Mr. Chairman, as you mentioned, a different time and place. It's interesting to note that the Police Chiefs Association had brought legislation to me this session that we passed, and it's passed third reading in the Senate, House Bill 4236, which would allow family members or designated family member in the case of a death or serious injury to view all body cameras, unredacted, even during the criminal trial. And so that is a part of law enforcement reaching out to try and bring some clarity and understanding to these terrible situations that, as you mentioned, from time to time we deal with the bad actors or not. So, but I just wanted to mention that we appreciate law enforcement doing that.
And I think it's a very good piece of legislation, but I think I read yesterday it's in trouble.
I know it's passed the Senate, so we'll,
I mean, did it pass without amendment?
as far as I know.
I did read something about that. I know I'm not, just so you know, I read something about
Yeah.
that it was in trouble. So I hope it passes.
Yes, thank you.
Because that is a very forward-thinking piece of legislation brought by law enforcement. When we talk about this case, again, these bills have to do with after the fact, not before the fact, or during the fact, gathering circumstances, and I think that's really important.
And you know, we're thankful that we had the dash camera. If not for the dash camera, there wouldn't be the evidence that there was.
Yeah,
And of
thanks
course-
Royce West.
Yeah, exactly. And then the body camera, of course, is even more additional information, obviously. So all of those things are very positive, Mr. Chairman.
And again, that they are. And, you know, we've only had a few cases in this country where, whether through settlement of a civil case or a criminal case, where somebody who has been, Sandra Bland, who has been affected by the actions of people in law enforcement actually won. Let me say it again, actually won. And the other piece is, I don't think in any other state there's been a piece of legislation named for someone that was admitted by the people who did it, victim of actions by law enforcement or jailers. No one. That's significant, y'all. Anyway, Representative Rosenthal.
Thank you, Mr. Chairman, and thank you, gentlemen, for being here today. Colonel, in your position, are you in a position to direct department policy statewide?
Yes, sir.
Excellent. So I wasn't here last time. I'm a first-time. I'm a freshman this year, so I wasn't part of this action last time. But it seems clear to me from the testimony and the back and forth today that there's certainly a possibility that there were issues with communication. So I'm not assigning fault. I'm saying two sides have a different view of what happened. That means the communication wasn't effective as a what I consider like a loop. So let me ask if you could commit to helping from your side. So in the case where something is delivered, something is requested by us in the legislature or another body, just to check back and say, did what we deliver fulfill your requirement, or is there some other way? Is there, you know what I'm asking? To just close the loop. When
Yes, sir. Based on your statement effective today, that will be the new policy. And moreover, we're going to have a list that's more detailed that will provide whomever requested the information so they can understand, or a very clear table of contents in terms of what exactly we provided.
I appreciate that. And then, so when I send off an email off into the ether, I have no clue if the other person has received it. I don't know if I've communicated until I receive something. So typically when I feel it's important for me to close that loop, I'll ask them to respond. Did you receive this? Is it appropriate? Something as simple as that really might be helpful.
Yes, certainly, yes, and we'll do that. And we'll bring this before our Public Safety Commission to codify.
I really appreciate your willingness, and thank you again for being here.
Thank you, sir.
Yes, Representative Collier.
Thank you, Mr. Chairman. I'm sorry, I've been watching the proceedings in my office, and I had to come over here because I just want to make sure, when you guys give up the information, when somebody makes a request for documents, and you respond to that because you say, I'm going to collect all the documents that's relevant to your request. So you know what you're putting into that thumb drive or on that disk or whatever you're sending to them, right?
Yes, ma'am.
Okay, is it operating procedure, is that standard procedure for DPS to just issue the information without a table of contents or any type of list specifying where these documents are located in response to their request?
I'll defer to General Counsel that I don't think we proactively do that, do we?
No, I think we provide an index of documents that we are providing. In this case, after the active criminal investigation, the folks started asking for the Ranger report, and that just the hard copy report was provided. And then that report contains descriptions of exhibits that were collected along the way. And then we would get requests for, like, please provide Exhibit 11.3, which was the cell phone video. So usually that's how it goes, that there's a broader production, and then folks look at that and clarify if they want anything specifically that's mentioned in that document and follow up. And that's what happened in this case.
But going forward, just based upon this discussion, but I want to make sure that anything we do send has a detailed table of contents, so there's absolutely with clarity in terms of what they receive from us.
But I'm just trying to figure out, how do you keep it? I mean, wouldn't you, if it's the way that you've kept it and you know how it is, but you don't present it to another person who's made a request, a reasonable request, a valid request for that information. So I'm just trying to figure out where the communication loss and translation.
Absolutely the standard that we would produce it in the manner in which we have kept it. That's the basic position of how we would present information. We don't jumble up information to present.
Okay. Well, I appreciate your willingness to be more specific in the future, but it's something that it's, I mean, it matters so much in this particular case that we have all of the information at our hands so that we can make a decision and resolve the issue expeditiously.
Absolutely. And I can tell you, we would have, with the family's permission, we'd have posted that video as well, if we would have only had it at the time we posted the dash cam video.
Mr. Chairman,
Yes.
are you saying that you asked the family if you could post her cell phone video?
No, that we didn't. We asked the family if we could, the dash cam, before we released the dash cam video publicly, we first got the approval of the district attorney, and then we wanted to visit with the family to see if they had any objections to us doing that, and they had none.
After you received the cell phone video a couple of weeks later, did you make that same request for the cell phone video?
No.
It was several months
We did-
later.
But before they, like in September, I think.
It was September 17th, and the investigation began July 13th.
How long was that grand jury impaneled?
I don't know the answer to that.
I don't either. We'll find out, though, and get back to you exactly what it was.
Appreciate it.
Yes, sir.
We've been joined, well, Representative Reynolds has a question, and then we've been joined by the person who passed the legislation and is the reason why we have dash cams, Senator Royce West. And I think that's very important, but I do want to save at least a few minutes. Oh, yeah, how soon can we get the what you gave in that thumb drive? Because now I'm going to have to do 50,000 questions to get the information and spend a lot of time on that, which I will do. Representative Reynolds?
Yeah, I'll be
and then
very, very
Senator
brief. I
West.
just wanted to ask for clarification. So with respect to Sandra Bland's actual cell phone video, did you communicate to the family that that video existed before it was released to the public?
You know,
I don't know the answer to that. Those communications with the family would have been with the criminal investigators, and I don't know that.
Because it was my understanding from the media reports that the family was not aware of that cell phone video. You
That's
you
my
would concede that,
understanding.
right?
Yeah.
So, and Mr. Dominguez asked a statement. You referenced the video that you went to the family to talk about, which was the dash
video.
cam.
Yes, sir.
But don't you think it would have been relevant to notify the family that in addition to the dash cam, that there was a cell phone video? Don't you think that would have been relevant?
I certainly think they would need to know that, absolutely. And I don't know that we didn't, but I don't know that we did. So
But if you did,
yeah.
don't you think you would have some documentation or some notification?
We do
that-
have the
that you did?
documentation of returning the iPhone, the cell phone back, okay, to the mother. We did have that documentation.
And how long did that take you?
It was, what, 2 years?
It was in 2017,
Right.
so.
So 2 years.
2 years, that's right.
And wouldn't you agree that was I mean, a long, way too long? Wouldn't you agree with that?
Yes, we had to wait till
Till you complete the
defense,
criminal-
yeah, until the criminal investigation.
And just last question. So the protective order that was issued from the Southern District of Texas, did that protective order specifically document that couldn't be released to the family, or that cell phone couldn't be, video couldn't be given to the family?
I don't know what the restrictions were.
I would have to review the protective order. It basically protected all of the evidence from the criminal investigation for public dissemination. I think it could have been released to the family as clients.
Sure.
In the litigation.
Right, but it's our understanding, and I guess the family can clarify that they didn't receive that. So that's what I have a problem with. Thank you.
Senator West, and then I know you have graduation to get to. We want to talk, we have a couple of more witnesses, and we're going to have to end at 10. And since members have a lot to do, we do want to at least have some conversations with the AG's office, and then we have someone from your DA's office in Dallas here to talk about a bill that they had this session that unfortunately didn't pass that relates to some of this. So, Senator West.
Okay, thank you very much, Mr. Chairman and members of the House. Thank you for letting me be a part of this. During the Sandra Bland investigation, I urged you to release the dash cam
Yes, sir.
footage. And I think there was, and you took the steps to do that, but at the time that the dash camera content was released, were you aware of the cell phone video?
No, sir.
Okay. When did you become aware of it?
I became aware of it, well, it may have been 6 months, but I can't even tell you exactly when I became aware of it, Chairman. But I can go back and review when I was briefed on it, but I don't think it was, I know it wasn't even discovered until when,
The report indicates that the criminal investigators first saw it on September 17th, 2015, so several months after the event.
So was this information known by the district attorney prior to concluding his investigation?
I've read his public representations that he was aware of the video and looked at that, but that's all I can say. That's what's been reported.
Okay, so he was aware of it.
Yes,
So
sir.
if he was aware of it, anything material, you would think that he would have taken from it and used it for whatever investigatory purposes he deemed fit. Is that correct?
Yes, sir.
Okay. Are we putting protocol in place to make certain that this doesn't happen again?
I'm going to put, yes, sir, I'm going to put the protocol in place to make sure that, sort of from a legislative standpoint, we send something over, that there's a very detailed list of what we're providing, number one, and number two, similarly, that we send to attorneys, that we're very descriptive in terms of what's in that, whether electronic format that we're providing.
Let me ask you this. When you present a case to the district attorney as the DPS, do you certify that any and all exculpatory evidence that has come into your possession as a result of the investigation has been turned over to the prosecutor for their purposes?
Yes, sir. In other words, and I keep referring to the report of investigation done by the Rangers, because that is our summary for the prosecutors. And that is a meticulous identification of all evidence and what that evidence is, so that the prosecutor has that and is ensured that we give both inculpatory and exculpatory information.
And that's a good practice, right?
Yes, sir, absolutely. And that's the advantage of having that report. And I think you've talked to any prosecutors why they like that Ranger report, because it has that summary, and it goes in not just in terms of the stuff that is relevant to the elements of the offense, but also everything else that was done in the investigation, and in great detail. And of course, the evidence, as you know, chain of custody is very important, but also exactly what's in that chain of custody and what's in that evidence.
Okay. Thank you, Mr. Chairman.
Thank you, Senator West. Thank you very much for being here. You've been, you've given us very good information today, and we usually in hearings like this, we find where there are cracks, not that intended or unintended, just that we need to do something better than what we're doing. And I'd say, you know, all of us, when I entered into this at all, I am not the criminal justice guy. I do healthcare in special districts. I don't do criminal justice. But when this occurred, it was very important that something be done. So we have jurisdiction in this committee, and that's why you get better information than when you do. Because I'm not bound by conventional wisdom. So, so thank you all very much for being here today. Appreciate you. I appreciate all you do to keep everyone in this state safe.
Well, bless you. And in the future, too, you may consider, and you may something you want to think about, Mr. Chairman, is that, you know, when the criminal investigation is done, there's no reason why the Texas Ranger, lead ranger on the investigation, couldn't be available to brief. So you can't even, not just to look at to the itemized list, but also can go over questions that you might have.
And so this is the deal. When we talk about transparency, number one, but when we talk about good relationships and people being forthcoming, instead of doing it in such a way that you have the superior knowledge and I have less, I have a limited staff. You have a whole agency and the Attorney General. I don't have the Attorney General. You have all of that. And I would think that in a spirit of good lawmaking, that there are things that you would say, hey, you didn't ask for this. But, you know, I think it's very important, instead of saying you didn't ask for it. I think that when in my work with the Health and Human Services agencies over time, they always say, hey, look, this is a problem that we see. They don't go into defense mode. They say, this is the problem we see, and you need to know this as a legislator. We got to that point at the end of the hearings. But before that, again, that's what people wonder why we ask the kind of questions we ask, because of the responses we get and the fact that you all know we're limited. But I've never been very limited in my life in terms of trying to find things out, even if I'm not as skilled as the attorney sitting on this dais. So that's just good government in the way I see it. But thank you very much for being here today.
Thank you.
And get to your graduation. Sorry to keep you
Thank you, sir.
longer. So we're running out of time. And what I want to do is, well, first of all, can Darren McCarty and Nicole Bunker Henderson from the Attorney General's Office for Civil Litigation please come forward? We're not going to be able to go into a lot of depth right now, but we will come back and do that. But just based on what you've heard from your client, is there anything different that you want to present based on what you've heard from your client in terms of how this information was given in discovery, since you were representing your client? How did you do that? And you heard the questions that were asked. If you could just, give us 5 minutes of what's your response to that?
Sure, and thank you, Representative.
And we'll come back and do another hearing, people, because this requires, a lot of the questions that need to be answered really should be answered by the AG's office, not necessarily the DPS.
Sure.
Please proceed.
Thank you, Representative Coleman and members. I don't know that we really that we either disagree with or really have a significant amount of additional input to offer on this matter.
Well, obviously you all did your releases together, so, clearly and we know, as Representative Theory said, what was put in that release that you gave to the AP probably at midnight, the night the story came out. So I think she asked some good questions about that. Can you respond to those questions?
Sir, I'm not familiar with what questions
you weren't in the room?
Referring to specifically.
You weren't in the room? Ask your questions again, Representative Theory, because I think that's
Representative Theory's questions. Yes, so.
Based on the story that, and you all, I got my Google alert at 11 o'clock, and I can tell you, you all would, I almost, when I read it, and this is opining, doth protest too much. So, continue, please. And then that's why we're going to come back to this.
Yes, sir. I think I have an overview of what you are asking. And I think our response is going to be very similar to what DPS is, which is that this file was archived. We reviewed the file from archives, and it very clearly showed the letter that General Counsel Atkins was referring to, which is the same letter under which we received the cell phone download from the county, from Waller County. So the plaintiff's counsel, my understanding, has produced their own hard drive to the county. The county then downloaded all of the cell phone content to that, produced it under their multiple cover letters, one referencing the volume of content, and then a second one actually transmitting that content, referencing Bates-labeled cell phone downloads to the plaintiff's counsel.
So I did have one clarification for everyone on that if that is the case, which I believe it must be if you're saying that and you can produce documentation of it, when they called it a cell phone download, was it every single thing on her cell phone, or was it the actual clip that is the subject of this hearing?
My understanding is that that production was everything on the cell phone. At that point in time, the Attorney General's office received the content in the same way. It is my understanding that we were able to determine from that content that there was potentially video footage on there. There's different kinds of footage on the videos.
So, for example, the average person, if you just click in, like my cell phone right now, it says videos, and I didn't know I took this many, but maybe because I've had my phone a while, 1,089. Some of them must be, I have a daughter, must take a lot of little clips of her. But was there any, it sounds from what Representative Huey was saying, there wasn't some kind of index that said, for example, number 9, 39-second video between Sandra Bland and the officer. I mean, because obviously if you gave them just a thumb drive and she maybe had 800 videos on her phone combined with 4,000 pictures and then 2,000 text messages and emails, it's possible, very possible then, that no one would have known that you all were producing a video that was relevant to the crux of the allegations in the case. So are you saying that when there was never, just for our own clarity here, there was never any kind of, that's what Collier said, any kind of index with a number that specified that he was getting a video clip of interaction between Sandra Bland and the officer?
I don't have, I did not observe an index. I don't have any reason to dispute that as an assertion that it was unindexed or that there was not a specific reference to that video.
And I think that makes a lot of sense, members, why the attorney
that's
would,
why I was
why the
saying
attorney
what
would
I was
say,
saying.
I've not seen it. If they had turned it over, I would have seen it, because perhaps they never were told that there was a video that was very relevant to the subject matter of the litigation. And that what I really think we need to do and come back is when we do a request for production, recall, you know this, we ask for certain things, and when you comply with it, typically the attorneys tell you what you're getting, so that you know that they were responsive to that request. So let's say, for example, request for production number 26 said any footage, dash cam or body cam or cell phone footage showing interaction between the defendant and the state or what have you, or the decedent. Then when you respond to that, you say you're specifically responding to request for production number what have you, and then you give that clip. It sounds like they just said, maybe it was a supplemental response because they didn't have it originally, and then when they supplemented their response, they just said, here's every single thing on her cell phone. But the truthfulness was, or the lack, maybe it was an omission through error. There was no conversation, it sounds
The
like.
Catholics, that's a sin.
That they never said, oh, by the way, when you get this phone back, we're giving you everything that she had on her phone in her whole life, as long as she had that phone. By the way, there's a really important video in here between her and the officer. So maybe that's the real confusion that came out of this whole newly discovered evidence.
I think that's
conversation.
possible, and I would be uncomfortable commenting on that since it was Waller County that produced that video to her. I do think obviously it is a best practice to have Bates labels
To follow up
identifying.
on Representative Theory, I told your government relations person about these very issues and
Yes.
for you all to be prepared to
Yes.
answer that. I guess he didn't talk to you?
Representative Coleman, we absolutely,
And I
that
said,
was
be
conveyed to us.
prepared because this is a question I have, not
Absolutely.
somebody else. I have, and the reason I have that question was because of the responsiveness of the DPS when we were doing our hearings and the way the information was presented to this legislator, to me, that I am skeptical about these circumstances because I would hate to be a reporter. If this is how legislators are treated, I'd imagine reporters, they just get angry.
Sure, and I think we're conceding that it was not indexed. That is not reflected in the file. I was simply speaking to any personal conversations that the Waller County lawyers may have had with the plaintiff's counsel, to which we would not have been aware. But we certainly were aware that it was a concern for you about the method of production.
So since someone questioned my comments, I don't like my veracity questioned. The information that we got, DPS, I just had my staff look at it, and he says, found the disc, and they are a mess. And I remember looking through them, and I remembered that there was no index. It was just stuff. And if, as Representative Theory said, the phone information was just stuff, then it's almost, I can't find stuff on my own phone. Nonetheless, if somebody gave, but see, this is what I mean when somebody acts like they reviewed it and said, we didn't do that. How can you not know if you did it or not? And I appreciate your being forthcoming about what you do know, that it wasn't indexed.
That's my understanding. I did not see an index.
Well, but again, you are the lawyer, the attorneys for the Department of Public Safety. You should know that.
Well, Mr. Chairman, I believe we do know that it wasn't indexed.
So
We
why-
received.
So they acted like it was. So which is it? You know it wasn't indexed, or it was indexed because they said they thought it was?
So maybe we're talking about two different things. When Ms. Micro Henderson was just speaking, she was referring to what was produced by Waller County, specifically the cell phone contents. What
And-
was produced by DPS under your legislative privilege is a
Oh, they
different-
never gave me anything that we could ascertain. I'm just being straight up.
And we wouldn't know about
You
that. So
wouldn't
we're
know.
So we're just
I'm
speaking.
mentioning that just because when somebody sits here and calls me a liar, I want to make sure that I send it to everybody so they know exactly what happened and why we're having this hearing. Because if I got information produced like that, that doesn't mean other people haven't gotten it that way, even with legislative privilege. And so it's about responsiveness in the legal process. And this is the legal process. This is a legal process.
And we take that very seriously at the Attorney General's office. I'm sure that our lawyers are probably tired of hearing me, that as a state, we hold ourselves to a higher standard, especially in discovery matters, because we sit at a different level and we have a lot of resources.
So this is the deal. And that's why we're going to call you back. We thank you for being here today, but we'll continue with this. It isn't the DPS that has a problem. It's you all if you didn't do your job. Because you're attorneys. They're not attorneys. You're the attorney for the state. If you didn't comply with discovery, that's disbarment.
We absolutely comply with discovery.
I'm just saying, you might want to go back and make sure you did in a responsive way, regardless of what Waller County said, and regardless of what the DPS said, and regardless of what the special prosecutor said, regardless of any of that, because you have a duty to make sure that whatever you're doing for your client is responsive. So just make sure you did. Don't give me a blanket answer. I'm giving you an opportunity to go back and take a look, because that's what Representative Theory is talking about. And when we can discuss it later. And just like with the DPS, send me everything you have, everything. Recorded, video, everything. Paper, whatever you have. And then we'll call the special prosecutor for Waller County, and we'll call all those other folks. And just like I tell a lot of people in government, you get to see what you send me first. So if there's something that you've talked about today that doesn't turn out to be the case, it would be very good if you just let me know.
Of course.
With the index too. So we'll come back to it, but I appreciate you coming today. I know that y'all have a lot going on, and, I respect the DA's office.
No more than you, Mr. Chairman.
Well, I'm just a guy. Thank you. We have a few minutes, and I appreciate this. Thank you, you all.
Thank you.
Thank you. To hear, we just have a few minutes, and I hate to do this, but Jason Hermes, it's Felony Chief, Dallas County Criminal District Attorney's Office, And they had a bill this session that deals with the types of things that we're talking about. And just to speak to that a little bit, and if at a later date, when we have more time, if you would come back and, I just wanted someone here who understands we have prosecutors on here, but who understands how you all have to deal with things like discovery and that type of information.
I appreciate you calling and asking us to talk to you in the committee about that. I'm with the Dallas DA's office. My name is Jason Hermes. I can say in 1 minute or less what our bill aimed to do. It brought clarity to all people who have an obligation in this system to turn over information to the adverse party, in our case, to the criminal defendants accused of crimes. It brought clarity because when this legislature passed the Michael Morton Act, you imposed upon us as prosecutors the absolute obligation to turn this stuff over. Sometimes we don't have the tools, though, to acquire all of the information, because sometimes the information is solely and exclusively possessed in a file with a law enforcement agency. So what this did for our partners in law enforcement, because they are our partners with the police departments, the sheriffs, the rangers who I work with extensively, it made it very clear that they, like the prosecution, are the state. And they have to turn over everything in their file to us so that we can in turn turn over everything in our file to the people that we have an obligation to provide that information to. So that was the gist of Senate Bill 2114.
And we'll send some things out on that. So let me ask you, as a prosecutor, in the discovery that comes from criminal defense attorneys, aren't they obligated to give you everything it is that they have in discovery so that you can present the case based on everybody having the same information?
The criminal defendants in Texas have no obligation to provide us with any discovery whatsoever.
So no obligation to provide you with discovery, but you have an obligation to provide them with discovery.
We have an obligation to turn over everything unless it's privileged.
Unless it's privileged. And has privilege creeped, meaning has it become more restrictive over time or less restrictive?
Less.
And that's because of actions taken by legislatures.
Largely, to an extent, also by the policy decision of district attorneys throughout the state towards, when in doubt, turn it over. That's a mantra I think every district attorney in Texas has.
Okay. We have hit 10 o'clock. That clock says 2 minutes till. So I don't know, what do we follow, cell phone or the clocks in the Capitol? When we come back, I would like for Chair Collier, to discuss some of these things. Here's Crim Jur. These are really important. But because we've run out of time, the House Committee on County Affairs stands adjourned.